Hello my dear students, I am Dr. Manoj Sharma. Today the topic of our discussion is economic theory of legal process. Let us introduce the topic. Economic analysis of legal procedures applies economic principles to understand and improve the legal system. This approach emphasizes efficiency in dispute resolution, considering the costs and benefits of various legal processes. Economic theory, particularly concepts like cost-benefit analysis and resource allocation, offers a lens to evaluate how laws and procedures can maximize societal welfare. For instance, in civil and criminal cases, the cost of litigation, including time, money, and emotional strain, is substantial. Economists study these costs to suggest ways and means to minimize them, aiming for a more efficient legal system that achieves just outcomes without unnecessary expenses. The importance of procedural efficiency in the legal system cannot be overstated. Efficient procedures reduce the time and cost of resolving disputes, benefiting not only the parties involved but also the society. For plaintiffs and defendants, efficient processes mean quicker resolution and lesser expenses. For society, they mean a more accessible and reliable justice system, which is crucial for maintaining social order and protecting rights. Moreover, efficient legal processes can lead to a more predictable and stable legal environment, encouraging economic activity and investment. In economic terms, an efficient legal system reduces transaction costs and uncertainty, which can otherwise inhibit economic transactions and the efficient functioning of markets. Historically, the economic analysis of law, often referred to as law and economics, emerged as a distinct field in the mid-20th century. The work of scholars like Ronald Coase and Richard Posner was pivotal in this development. Coase theorem, for example, introduced the concept that under certain conditions, parties can negotiate to resolve conflicts efficiently regardless of the initial allocation of rights. This idea has profound implications for understanding legal disputes and the role of law in society. Posner's work further explored how laws could be designed to promote economic efficiency, arguing that many legal rules implicitly or explicitly serve this goal. Over time, the field has expanded to cover various aspects of law, including property rights, contracts, torts, and criminal law, using economic principles to analyze and critique legal structures and practices. The economic analysis of legal procedures provides valuable insights into making the legal system more efficient and just. By focusing on the costs and benefits of legal processes, this approach helps identify ways to reduce unnecessary burdens on parties and improve the overall functioning of law. Now let us talk about costs of litigation and dispute resolution. The cost of litigation and dispute resolution is a significant economic concern within the legal system, impacting both the parties involved and the society. Litigation expenses encompass various costs, including attorney fee, court fee, expert witnesses fee, the opportunity cost of time spent in the legal process. These costs can be prohibitive, deterring individuals and businesses from pursuing or defending legal claims, even when they have a valid case. The high cost of litigation can lead to inequities in access to justice, where only those with substantial financial resources can afford to engage fully in the legal system. This economic barrier can result in the under-enforcement of legal rights and a lack of accountability for wrongful actions, thereby undermining the effectiveness of the legal system as a tool for justice and social order. The costs of litigation and dispute resolution also play a crucial role in the evolution of common law. Common law develops through judicial decisions made in the individual cases, and the cases that proceed to trial often shape legal precedents. However, the high costs associated with litigation mean that only a subset of disputes, often those involving substantial amounts of money or significant legal principles, make it to the court. This selective litigation can skew the development of common law towards economically significant issues, potentially overlooking or underdeveloping areas of law that affect less financially significant or less frequently litigated issues. Moreover, the threat of high litigation costs can lead to settlement in cases where parties prefer a predictable outcome over uncertainty and expenses of a trial. While settlement can be efficient and beneficial, they can also prevent the development of clear legal principles, as they do not create binding precedents. As a result, common law may evolve in a piecemeal and potentially inconsistent manner, influenced by the economic considerations of the parties involved rather than the broader public interest. To address the economic burden of litigation, various strategies have been proposed and implemented to reduce these costs. One common approach is the promotion of alternative dispute resolution methods such as mediation and arbitration. These methods are generally faster and less expensive than traditional court litigation, providing parties with more control over the process and outcome. Another strategy is the adoption of cost-shifting rules, such as loser pays principle, which can discourage frivolous lawsuits by making plaintiffs bear the defendant's legal costs if they lose. Additionally, reforms to streamline court procedures, like simplified rules for small claims or fast-track processes for certain types of cases, can also reduce litigation costs. Technological advancements such as e-filing and virtual hearings further contribute to cost reduction by minimizing administrative expenses and travel costs. These strategies not only lower the economic barriers to justice, but also help alleviate the burden on judicial resources, allowing courts to operate more efficiently. The cost of litigation and dispute resolution is a critical economic issue that affects access to justice, the efficiency of the legal system, and the development of common law. Efforts to reduce these costs through ADR, cost-shifting rules, procedural reforms, and technological innovations are essential for ensuring that the legal system serves its fundamental purpose of delivering justice fairly and efficiently. By mitigating the financial barriers to legal action and ensuring that important cases are heard, these strategies contribute to a more equitable and functional legal system that can adapt and respond to the evolving needs of society. Now let us discuss settlement versus trial. In the legal process, the choice between settlement and trial is a critical decision for both plaintiffs and defendants, driven by a common interest in avoiding the costs and uncertainties associated with litigation. Settlements allow parties to resolve disputes without the expenses of a trial, which include a legal fee, court costs, and the time and stress involved in litigation. Additionally, settlements provide a level of predictability and control over the outcome that trials do not, as they allow parties to negotiate terms rather than leaving the decision to the judge or jury. This predictability is valuable because it helps parties avoid the risk of an unfavorable judgment. Therefore, settlements are often seen as a mutually beneficial solution that saves resources and allows both sides to move forward more quickly. Despite these advantages, not all cases settle out of court. There are several reasons why cases may proceed to trial. One reason is the presence of significant factual disputes or legal issues that require a formal adjudication to resolve. In some cases, the parties may have differing interpretations of the law or facts that are so fundamental that only a court can decide them. Another reason is the potential for a high-stakes outcome, where the financial or reputational consequences are substantial enough that one or both parties are willing to risk the uncertainty of a trial. Additionally, some parties may proceed to trial as a matter of principle to establish a legal precedent, or because they believe they have a strong case that will likely result in a favorable judgment. The differing perceptions or optimism model offers a framework for understanding why parties may choose to go to trial despite the risks. According to this model, trials occur when both plaintiffs and defendants are overly optimistic about their chances of winning. This mutual optimism can stem from each side's unique perspective on the evidence or the law, leading them to believe they have a better chance of success than they do. As a result, neither party is willing to settle for what they perceive as an insufficient offer, thus leading to litigation. The optimism model suggests that the likelihood of a court litigation increases as the costs decrease and as the potential stakes increase, because these factors enhance the perceived benefits of going to court compared to the risks. Another key factor influencing the decision to settle or go to courts is the presence of asymmetric information between the parties. The asymmetric information model posits that litigation may occur when one party has private information about their prospects in court proceedings that the other party does not have. For example, a plaintiff may have evidence or information that strengthens their case, which the defendant is unaware of, leading the plaintiff to demand a higher settlement than the defendant is willing to pay. Conversely, a defendant may have information about defenses or mitigating factors that make them confident of winning, prompting them to reject settlement offers. Asymmetric information can thus lead to divergent expectations about the outcome, making it difficult for parties to settle. The choice between settlement and litigation is influenced by a complex interplay of factors, including the common interest in minimizing the costs, the specific circumstances of the case, and psychological and informational dynamics. Understanding these factors is crucial for legal practitioners and policymakers aiming to create a more efficient and fair legal system. By addressing issues like mutual optimism and information asymmetries, it may be possible to reduce the number of cases that proceed to trial, thereby saving resources and reducing the burden on the courts. Now let us discuss factors influencing settlement and the litigation decisions. Settlement and litigation decisions are influenced by several factors. Litigants' risk preferences play a crucial role. Risk-averse parties may prefer settlements to avoid uncertain outcomes. Asymmetric stakes arise when one party, often a repeat player like a corporation, has more at stake or resources, influencing their willingness to proceed to court proceedings. The burden of proof impacts plaintiffs, as those facing high proof requirements may opt for settlement to avoid the difficulty of proving their case. Now let us discuss legal rules and their economic implications. Legal rules significantly influence the economic landscape of litigation and dispute resolution. One notable rule is the English loser pays rule, which requires the losing party in a lawsuit to pay the legal costs of the winning party. This rule has a profound impact on the behavior of litigants. Economically, it serves as a deterrent against frivolous lawsuits, as potential plaintiffs must consider the risk of not only losing the case but also bearing the defendant's legal costs. This risk can make plaintiffs more cautious and likely to settle, thereby reducing the number of cases that proceed to trial. However, the rule also has the potential to discourage legitimate claims, especially from less wealthy plaintiffs who cannot afford the risk of a large financial loss. Thus, while the English rule can promote efficient use of judicial resources by discouraging meritless cases, it may also create barriers to access to justice for individuals with valid claims but limited resources. Rule 68 of the Federal Rules of Civil Procedure in the United States offers another approach to promoting settlement. It allows a defendant to make a formal settlement offer, and if the plaintiff refuses and subsequently fails to obtain a better outcome at trial, the plaintiff must pay the defendant's post-offer costs. Similarly, in India, the Code of Civil Procedure, Order 12, Rule 4, postulates that any party may call upon the other party to admit facts. And if the other party refuses to admit the facts, the cost of proving such facts shall be borne by the party so refusing. This rule economically incentivizes plaintiffs to carefully evaluate settlement offers, knowing that rejecting a reasonable offer can lead to financial penalties. The prospect of having to pay the defendant's costs creates a strong incentive for plaintiffs to settle, particularly when the trial outcome is uncertain. These procedures thus expand the settlement range and encourage early resolution of disputes, which can save both parties significant costs. However, the effectiveness of this rule depends on the parties' assessment of the likelihood of winning the courtroom battle and the perceived fairness of the settlement offer. There is another factor, like the contingent fee, where attorneys are paid a percentage of the plaintiff's recovery. This is another legal mechanism with significant economic implications. This fee arrangement aligns the interest of the lawyers and their clients, as attorneys only get paid if the case is successful. A contingent fee can motivate lawyers to work diligently on behalf of their clients, as their compensation depends on the outcome. Economically, this arrangement makes legal representation accessible to plaintiffs who might not afford an hourly legal fee, as they pay nothing upfront. However, contingent fee also have potential downsides. They can encourage lawyers to settle cases quickly, to secure their fee without prolonged litigation, potentially leading to undersettled cases. Additionally, the prospect of a significant fee might tempt lawyers to take on cases with dubious merit, hoping for a settlement. This can contribute to an increase in frivolous lawsuits, as defendants might settle such cases to avoid the costs and uncertainties of litigation. These rules profoundly impact the economic dynamics of litigation. They shape the incentives and behaviors of litigants and advocates, influencing decisions on whether to settle or proceed further with the litigation. While they can promote efficiency and access to justice, they also pose challenges, such as potential barriers for legitimate claims or the encouragement of frivolous lawsuits. A careful balance in designing and applying these rules is essential to ensure that they promote fair and efficient legal outcomes without unduly burdening any party. Now, let us discuss frivolous suits, court delays, and legal standards. Frivolous suits, characterized by their lack of substantial merit, represent a significant economic challenge within the legal system. Economically, these suits often exploit the threat of lengthy and costly litigation to coerce settlements from defendants, regardless of the suit's actual merit. This opportunistic behavior increases litigation costs, strains judicial resources, and contributes to court congestion. The prevalence of such suits can lead to increased legal expenses and delays for both plaintiffs and defendants, as well as a general erosion of public confidence in the justice system. Frivolous litigation not only burdens the court system, but also diverts attention and resources away from cases that genuinely require judicial intervention. Court delays substantially increase the problems caused by frivolous suits and have profound effects on dispute resolution. Extended timelines can result in increased legal costs for both parties as ongoing legal work and repeated court appearances accumulate. Delays can also reduce the value of legal remedies as prolonged cases may lead to financial hardships for plaintiffs, loss of evidence, and deteriorating witness testimonies. These delays can also diminish the efficiency of the legal system, resulting in a backlog of cases and slower justice delivery. Defendants may strategically use delays to their advantage, pressuring plaintiffs into settling for less favorable terms to avoid the continued uncertainty and costs of prolonged litigation. This tactic is particularly effective against plaintiffs with fewer resources, who may be more inclined to accept a settlement simply to resolve the matter quickly and avoid further financial strain. Standards of proof in legal proceedings are essential for balancing the risks of false convictions and false acquittals. In criminal trials, the standard of beyond a reasonable doubt is employed to minimize the risk of wrongful convictions, given the severe consequences such as imprisonment or loss of liberty. This high standard reflects the significant impact of criminal verdicts and aims to prevent miscarriages of justice by requiring a very high level of certainty before a conviction can be made. In contrast, civil courts can use preponderance of evidence standard, which is somewhat equivalent to the balance of probabilities. This lower threshold is appropriate given the typically lesser consequences of civil disputes, where financial compensation or specific performance is the usual remedy. Differentiating standards of proof helps balance the cost of legal mistakes by ensuring that the gravity of the consequences aligns with the level of certainty required for a verdict. The value of lawsuits can be assessed from both social and private perspectives, often revealing discrepancies between these values. Socially, lawsuits can have substantial benefits by enforcing legal norms, deterring wrongful conduct, and promoting broader societal justice. For instance, lawsuits against corporations for environmental damage can lead to improvements in industry practices that benefit the public. However, the private value of lawsuit is more focused on individual gains, such as monetary compensation or personal relief. This divergence can lead to situations where individuals pursue lawsuits primarily for personal financial gain, even if the broader societal benefits are minimal. Conversely, potential plaintiffs may be deterred from pursuing cases with significant social value due to high costs or limited personal returns. This misalignment highlights the need for a legal system that not only incentivizes the pursuit of meritorious cases, but also considers the broader social impact, ensuring that both private and public interests are adequately served. Now let us discuss efficiency in legal evolution. Efficiency in legal evolution hinges on several key conditions, that ensure that the legal system adapts towards more effective and equitable outcomes. For the law to evolve efficiently, inefficient laws must be more likely to be litigated than efficient ones, and judges must be impartial, not biased against efficiency. Precedent plays a crucial role in this process by guiding judicial decisions based on past rulings, providing stability and predictability in the law. However, reliance on precedent can also entrench outdated or inefficient rules if not critically evaluated. Judicial decision making, therefore, must balance respect for established norms with the need for reform. Judicial bias and selective litigation can impact legal evolution significantly if judges or parties preferentially address cases that reinforce personal or institutional biases rather than fostering efficiency. This can skew legal development. Efficient legal evolution requires that both the judiciary and the litigants actively seek and address inefficiencies, ensuring that legal standards and practices continuously improve to better serve justice and societal needs. Now, let us conclude the topic. The economic analysis of legal procedures reveals critical insights into how the legal system can be optimized for efficiency and fairness. By applying economic principles to understand the costs and benefits associated with litigation, this approach highlights the importance of procedural efficiency in reducing the time, cost, and emotional strain involved in legal disputes. Historical development in this field, influenced by foundational theories and scholars, has shown that economic analysis can profoundly impact legal processes. The cost of litigation and dispute resolution, with its significant economic implications, underscores the need for strategies to reduce expenses and enhance access to justice. These strategies, including alternative dispute resolution and cost-shifting rules, etc., aim to alleviate financial barriers and streamline legal proceedings. That is it for the time being. Thank you very much. Happy learning.